David Davis.
Thank you, Mr Deputy Speaker. When I was listening to my right honourable friends, the member for Rushcliffe, earlier talking about steaming open letters, I was reminded of the American Secretary of State, Henry Stimson, in 1929, when he shut down the State Department's code-breaking department with the words, "Gentlemen do not read the mail of other gentlemen." Now, that was quaint even then and was quickly reversed. Today, everybody recognises the vital importance of targeted surveillance against dangerous criminals of all sorts. And we all in this House, I think, want to see the intelligence agencies and police forces have effective measures that help them do their job. I don't think there's any difference there. Now, the presentation of this bill, however, has required the Home Office to publicly avow a vast range of surveillance powers that today has existed in secret. And these powers do look like they are rather greater than those used by our allies, certainly greater than America or Germany. Some of them would have been struck down as unconstitutional in both of those countries. What seems to have happened is that these powers have developed over the last 20 years using a vast thicket of existing legislation, largely without the knowledge of Parliament. Now, many of the agency's current capabilities were never envisaged, never considered when the legislation that underpins them was created. I mean, it's certainly true, I can say with absolute certainty this is true of the Secret Intelligence Service Act, which as a minister I took through Parliament, and it was never envisaged that it would provide for example, the acquisition of bulk personal data sets. Now, I can give many examples, but we're on brief time, so I'll give the House a single example of how the creep of surveillance has happened, with the best of intentions: the erosion of legal privilege. Up until the late 1990s, when an intercept or bug was recording a criminal suspect, the moment that suspect talked to his lawyer, the bug was turned off. The recording was turned off. That's what used to happen. Absolutely clear. Then in 2000, we had RIPA. RIPA was silent on legal privilege. It was simply not mentioned in the Act at all. Yet the government later, the government of the day, chose to interpret this silence as acquiescence that RIPA does allow for the surveillance of privileged communications. So we went from turning the recording equipment off to privileged conversations being recorded and kept in a red-flagged separate database. That was how it worked. This eventually did come out in 2009 when two law lords, Phillips and Neuberger, expressed incredulity that, in their words, the government had in effect been sanctioning illegal surveillance. At least in these initial stages, the illegally collected information was red-flagged and kept from being allowed to pervert the judicial process. Then, during or before 2014, the rules were changed to allow the government lawyers to see the intercepts. Now, this is extremely dangerous to the operation of justice. It destroys or can destroy equality of arms. That, in turn, could undermine perfectly proper cases against terrorists, which could lead to them being freed on the basis of an improper prosecution. Now, I cite that example, that single example of the actions of the agencies and Home Office. It's important in its own right, but I cite it here as a demonstration of what has been happening in the last 20 years. The agencies in particular, but police too and other organisations, because of the difficulty of the counter-terrorism task and the opportunities afforded by technology, have quite understandably sought to extend their powers, in this case using the silence of RIPA to erode legal privilege. Now, we see this again and again. We saw it in the 1994 SIS Act, the one I mentioned, and the 1984, ironically, the 1984 Telecoms Act, which was actually a privatisation act, or a follow-on from the privatisation of British Telecom. This is why this bill must be drafted incredibly precisely, incredibly carefully. The language of the bill as it stands is designed to confuse. The previous Home Secretary, a member for Rushcliffe, and I were talking about this, but both of us had trouble understanding the 250 pages of this Act as it stands. Now, that has to be put right, and that's important at report stage, why I'm concerned about report stage. But there are many other significant flaws in this bill which have to be put right. the lack of sufficient privacy protections, the collection of ill-defined bulk personal data sets, wide and too easy access to retained communications data, prime ministerial appointment of judicial commissioners, on and on and on. I've got about a dozen items here, but I don't intend to go through all of them. But what I do want to touch on in the last couple of minutes is the bulk capabilities. Now, the House should be under no misapprehension as to how broad and how potent these powers are, even though the ISC chairman was quite right in saying that the agencies do try to be as economical as they can with using them. They do allow the interception of vast quantities of foreign and domestic communications, acquire records of entire nations' phone and internet records, and permit industrial-scale exploitation of phones and computers. Now, the question we have to ask in this bill, the fundamental question is, are these powers effective? In the US, bulk collection of US citizens' data has been heavily curbed, as it is considered, and I quote their own words, not essential to preventing terrorist attacks. Most damningly, the American president's own Privacy and Civil Liberties Oversight Board said, and again I quote, they were aware of no instance in which the NSA's bulk records program directly contributed to the discovery of a previously unknown terrorist plot or disruption of terrorist attack. And there are genuine concerns that this collected all approach actually makes things worse, the Bill Binney point that the honourable member who just spoke referred to. And I say this to the House and to the ISC. The equivalent committee to the ISC in the USA, the Senate Intelligence Committee, has got just the powers, in fact more the powers that the ISC has, was initially persuaded that bulk data collection had prevented over 50 terrorist attacks. It was persuaded of that. Then the staff of the Senate Judiciary Committee went through the claims one by one, and they found there was only one case. And it was not a terrorist attack, it was an $8,000 money laundering case. So that's how useful that was, and that's why they have been curbing it. Now, this bill, or something like it, is absolutely necessary. It replaces 66 plus other pieces of statutory mechanism. So we've got to have, in the interest of transparency, something to put in its place. But it grants sweeping powers, in my view, so far, insufficient safeguards and not enough consideration for privacy. So in my view, it's up to this House in that report stage, and I ask all parts of the House to press for more time on that, to bring reasonable amendments to legislation that will put in place a law which actually will be a world standard. Because I'll finish on this point. Any other country in the world, but most particularly the most unpleasant ones, are always very happy to use Britain as an example of something that they shouldn't be doing. That's why I opposed 90 days and why I opposed many other illiberal things that too many governments in this House have done.